Good morning. My clock says 10 o'clock. Welcome on behalf of the City Commission. I'm Mike Peterson. We're going to start. Mike's going to make a few opening comments, and then I'll lead with an opening question. The commissioners will take turns with questions, and then I'll wrap up with a closing question. So, Mike?
Good morning, everybody. My name is Mike Thornton, Purchasing Manager. Today is February 23rd, 2022. This is the interview meeting between the City of Leesburg and Shepard Smith, Colmar, and Han, PA, for request for proposal 220042 for City Attorney Services. An interview session has been scheduled with the 4 top-ranked firms. This is the third of those 4 interviews. We have one more following this. This interview provides an opportunity for firms to address questions asked by the city. The interview is scheduled for 45 minutes. The time will start when the first question is asked. The interview questions have not been provided to any of the firms, and with that, I'll turn it back over to the mayor.
Thank you, Mike. I'll just start and ask you to just provide some background on your firm and your qualifications for the city attorney position.
Sure, Mayor, I'd be happy to. My name is Andrew Hand of Shepard Smith, Colmar & Hand. I have here today as well as Patrick Brackens of our firm. Our firm has a long, rich history in local government representation. And going back, that's how our firm was founded in 2008. And it was founded after practicing in this practice area and named under some other firms going back quite a long time. It's not something, local government representation is not something we do exclusively. We're a full service law firm, but it is the cornerstone of representation that we provide. All of our attorneys are expected to become board certified in their areas of expertise, whether they are local government attorneys or not. And currently we have 6 attorneys who practice in the local government area. So we are able to handle anything from a large scale to a small scale when it comes to local government service needs.
And I'm Patrick Brackens. I'm board certified in city, county, and local government law. The only attorney in our firm who is not yet certified is taking the test and is qualified this year to take the test, and we fully expect him to be board certified by August. As Mr. Hand mentioned, we are a full service firm. I would say 70% of our firm is dedicated to the local government work, but at the same time, we're not so overextended that we have so many local government clients that we can't give our full and complete attention to those clients that we do have. For example, Mr. Hand is city attorney for the city of Mascot and for the city of Denellen, and those are his primary cities. I don't have a city currently where I'm city attorney, but I'm general counsel for the Winter Park Housing Authority. I'm also assistant city attorney for all of our local government clients. I'm the special magistrate for the City of Orlando's red light camera program, and I'm counsel to the Orange County Code Enforcement Board. In addition to that, we have a fairly robust litigation practice that benefits our local government clients in 2 respects. One, whether I'm sitting at a planning commission meeting or sitting at the city commission meeting, my background is in litigation. I spent 8 years as a law clerk to a United States magistrate judge, which is the primary trial judge you see before trial in federal court. Before that, I was a staff attorney for the 9th Judicial Circuit here in Florida, where we handled the kind of things you see. So the code enforcement appeals, when they go up on Chapter 162, those were the things I would work on. Or the petitions for writ of certiorari, those are the things I would work on. But my mindset is litigation. So when I'm sitting there and you're doing a quasi-judicial hearing, I'm thinking about the record in the event that you have an aggrieved party that's going to appeal. That's kind of where my mindset is. But in addition to that, we provide extensive sunshine, public records, quasi-judicial, and ethics training to all of our clients. We also do that for cities we don't represent generally. The other thing that we do, because of our litigation experience, is we're frequently hired by cities and other agencies for special litigation purposes. For example, right now, I'm not going to get into too many of the details, the cases are on appeal, but We successfully represented the city of Satellite Beach in a fairly entertaining fact pattern sunshine law violation case, and the city of New Smyrna Beach, and also a very entertaining fact pattern case for sunshine and Section 1983 violations. So that the other thing we do that was mentioned in some of the other proposals is we do represent private parties on occasion before local governments. And that's actually to your benefit for a couple of reasons. It allows us to charge a below market rate for our local government services because we're able to charge market rates for our private clients that we represent. We don't do a whole lot of that work. I'd say maybe 10% of it is representing on the opposite side, but it's a big state. Central Florida is a large area. We don't currently represent anybody against any entity in Lake County. Most recently, we represented the city of Claremont for a revocation of a conditional use permit and certificate of occupancy for an all-male review that happened at a restaurant, and that was in January. So that gives you a little bit of the background of our firm and who we are.
No, thank you both very much. So I'll start now with Commissioner Burry.
Hi, I'm Jimmy Burry. I represent District 1. What are some of the issues facing our city that you're familiar with, and have you been following them? What can your firm bring to us that'll help us overcome some of these things?
One of our primary areas in practice in representing local government, of course, full service, we represent soup to nuts everything that local government sees. But one of the things that we're focused on is land use. It's the hottest practice area in Florida for a number of reasons. In following Leesburg, one of the things that I've done over the years, I've been a professor at the University of Florida, designed a land use course. So I started paying attention to Leesburg probably about 10 years ago, and just what's going on here in Lake County, and some of the teaching that I taught students, and what the development issues are in different areas of the state. In looking at Leesburg, one of the things that we've been following is just how development is unfolding and what's going on in Lake County in general, as well as seeing some of the things happening here when it comes to redevelopment and your CRAs. That is one particular area where we're extremely well equipped to help you all out. Our firm represents as general counsel the FRA, which is the Florida Redevelopment Association. It's very similar to the League of Cities, but it's sort of the overarching, it's where CRAs and cities go when they need some help with CRAs. And so whenever you have a CRA development director who needs assistance, they contact them, it comes to us. And in addition, we're special counsel. One of the things that Mr. Bracken's touched on is kind of the diversity of things we do for local government. Special counsel, and we can talk a little bit more about some of the other areas, but that is one of our biggest practice areas in this land use sort of thing. So when it comes to redevelopment, when it comes to land use, I think you'll find that we're top notch, and that's where we really excel.
Just briefly to add to that, I was at your last meeting when you talked about the scores and who you wanted to interview, and that was a large meeting. You had a lot of items on the agenda, a lot of ordinances coming for first reading about development. One of the things we propose, and I believe all of our local government clients have adopted, is a pass-through ordinance, which Mr. Hand can talk about. That also goes to what I call the below market rates that we charge for local government work. A pass-through ordinance allows us, when we have to review these large development plans, it allows us, the city, to pass through the costs of our review to the developer at market rates. Not the rate you charge, but the rate we're charging them. Since we're reviewing the product for them, they pay. In addition, I can also see just from my time driving around here that you have several CRA-related needs and redevelopment, and that is, as Mr. Hand said, something that we have a lot of experience in. Frequently, we get called when there are problems with the CRA or problems with the audit for the CRA, and we get called to fix things that we didn't help create. So those are some of the things we would bring to the issues that you're facing in the city. Yes, sir.
Good morning. What role do you see your firm taking in our organization if you were selected?
Sorry about that. I didn't realize I didn't have to hold it down the entire time. We view the city attorney role, when I say we, of course, our firm, we view it as really empowering local governments, local officials to make good decisions. And that's essentially the role that I see the city attorney performing. We understand that we're not part of the politics. Shouldn't be. We're here just to give you the answers that you need so you can make those good decisions. In addition, of course, our role is to handle litigation needs of the city, to coordinate and facilitate the jobs of staff, support them, and answer their legal questions so that they too make good decisions and that they follow the correct procedures. And that is the short of it. If there's anything specific you'd like to discuss, I can discuss
Just
that
follow
too.
up, will we be assigned a single attorney, or will we have multiple attorneys who will come in, or will be your firm give us one attorney who we will see every meeting?
The firm essentially will be providing the representation. So when it comes to city council meetings, that is something we would have to discuss with you. I do have an obligation on the second Monday of the month, which causes conflict. Mr. Brackens does not. So it would be your choice when it comes to city commission meetings, whether there was going to be one attorney at one at the other, or to go with an attorney in our firm who does not have a conflict. As far as all of the other meetings for various boards and so forth, we will be assigning an attorney to that particular board, and that would be the primary. We call them primaries and secondaries. So for each board, you'd be seeing the same attorney for those meetings.
So generally, it would be Mr. Hand would be coming to the second meeting of the month. I would come to the first meeting of the month. It would be your choice, or who you would want to come to the planning commission meetings, things like that. But basically, the bottom line is it would be me or Mr. Hand. In the event there was a special meeting or something like that, where there was a conflict and either of us could actually attend, and that very unlikely event, it would likely be Drew Smith in our office, who is also board certified in city, county, and local government law. But Mr. Hand and I would be the primary attorneys that you see and you speak to and have access to on a daily basis.
Could you talk about any specific experience you have with either an electric or gas utility, whether municipal or otherwise?
Sure, I can. Several of our clients have their own utilities. I know that Leesburg is not looking to divest its utility system, of course, but I did and have provided extensive, from the soup to nuts, legal advice in divestiture of a $13 million utility over the last few years. As far as
which one was that? Sorry,
this was up in Marion County.
And it was
the city of Pinellas utility.
Which utility? Sorry, what, like electric, gas,
Water.
something? Water utility.
Water.
Okay. I'm specifically interested in either electric or gas.
Sure. With electric utilities, we provided representation to Mount Dora previously, and have done all of their utility work up to until the last few years ago. Water, I have a lot of experience in water. Electric, we've also dealt with. We don't represent Winter Park, but we're right next door in Maitland, so we've dealt with some electrical issues there.
Good morning. How accessible is your firm on a daily basis on responding to phone calls or emails from staff or commission with questions?
Short answer is we're available 24 hours a day. You all would each have our cell phone numbers. You would have our office number. You would likely have not only my number, Mr. Hand's number, Mr. Smith's number. If anyone was working on a particular project, so if Cliff Shepard in our office was working on a particular project with that member of staff, they could get a hold of them. You know, we do have meetings. We call people back the same day. Being in constant contact is not, it's not realistic just because of the way schedules go, but in terms of getting a call back that day, that happens.
Thank you.
Yes, sir.
And I would add, if there's, in the case of an emergency, like I said, we're a medium-sized firm, and if there is a situation that does arise where I may not be available, or Mr. Brackens is not available, for whatever that reason may be, there will be somebody who is. And whether it's someone that has an extensive relationship with the city or who only works tangentially and on small parts here and there, we make sure that there was coverage and that whatever emergency was addressed immediately until one of us could get on it and finish it out for you.
And, you know, our assistants, the folks that answer the phone and route our calls, they have everybody's cell phone number. They get you an attorney from our firm. In the time I've been there, there's never been a situation where an attorney wasn't available such that we had to refer them to another attorney for a time-sensitive matter. It's just never happened with 6 attorneys in that practice area. You'll get one of our attorneys.
City Manager, do you have any questions?
A little bit abstract, but a couple of the things in some of your answers you've mentioned make me wonder this. So as we're managing a community, or you guys are lawyering our community, sometimes you let the sleeping dog lie. How do you approach that? If you would come into Leesburg, you see the way we've done some things, maybe you seem different, maybe there's an inclination to have immediate change to avoid litigation, sometimes maybe not. So how would you approach that? And do you see sleeping dogs that we need woke up, or?
Mr. Hand can talk about this in specific with one of his clients, but there are, you know, when we look at land development codes, those are some things we have experience in drafting for our clients. Sure, we see areas that could be improved, or, oh, this could be a problem one day, or we're dealing with an issue, let's say, of setbacks next to a river or a lake that maybe wasn't handled the way, if we were involved in it, we thought it should be handled. Usually when that happens, we're not the policymakers. So we don't come in and say, hey, you need to change your code right now. What we do is we talk to the staff member, the planning director, the mayor, whoever it may be, if that issue comes up. And usually that's by a phone call, not by an email. We don't create public records that are going to cause a problem for our clients. But it's you make the policy decisions. You guys make the policy decisions. We're there to provide you advice, but at the end of the day, sleeping dogs sometimes do lie. One example is, for me personally, in the city of Flagler Beach, they had an issue where you had protesters in Veterans Park carrying signs that said F, but spelled out the president. And the residents wanted those folks arrested. And the politicians, obviously, you want to be responsive to your constituency. But at the end of the day, what was decided is we would provide a memo blandly explaining what the First Amendment allows and what it doesn't. And then sleeping dogs were let lie. And yes, the lawyers were blamed. Sometimes that's our role, to be blamed. We'd like to help, but the lawyers tell us, that's okay, that's what we're here for, and a lot of times. So I'll defer more to Mr. Hand on that, but those are our experiences. We try to use our common sense, always protecting our client, which is the city, unfortunately not you individually, but the city, and not creating more problems for you.
I think Patrick said it well when he talked about us not being policymakers, knowing that we're not decision makers. The way that I handle those type of issues when they come up, and when I say those issues, just what you referred to kind of abstractly, sleeping dogs, lying, is to go ahead and have that dialogue with the city manager. City manager, I've noticed this. These are what I can identify as something that could potentially be a problem, and essentially have a discussion, perform a risk analysis, You know, this is the likelihood that something may happen. Perhaps it's very problematic, where it's like, we really should fix this. Ultimately, it's up to you in addressing it with the council. It's up to how the council wants to move forward. But we'll take a look at it, see how bad the problem is, and where we're at. Then have that discussion, and then make a plan to go from there. And if it's something that perhaps is just a minor problem, it needs to wait, that again is all up to you. So whatever decision you make, you know, we provided the advice, at least made the identification, and then from there, how you'd like to proceed, it's all up to you. And in local government, it's something that comes up frequently. I've never seen a perfect code. I've never seen, you know, situations where there are some things that really would be cost prohibitive to handle. And so it's just having that understanding, looking at it, well, how could it be fixed? How reasonable is it to fix it? And what is the plan, and how would you like to handle it once we've given you all the information? Again, going back to helping empower everybody make good decisions.
Another purely hypothetical example. Let's say your city had red light cameras, and you were going through the process of re-permitting those cameras with the FDOT. And let's say the FDOT told you, you know, I'm not sure how you were given a permit in the first place because those cameras are near a railroad track and you can't have those cameras there. Okay, what do we do? Well, I don't know, hypothetically, I would imagine you'd have a conversation with the city manager and the town mayor, and maybe it would be time for a political decision to stop red light cameras without creating a public record trail that says we have a problem with our FDOT cameras and create legal issues that you don't need to have, hypothetically. So that's kind of how we do it. We always think, it's always in the back of our mind about the consequences for the actions of the email. Should I send this email? Should I pick up the phone?
Thank you very much. As you well know, the city owns the airport. I was curious about your experience with municipal airports.
We've represented the city of Popka, which also has a municipal airport. And so we've dealt with airport issues in our representation of the Popka.
No, great, thank you. Commissioner Burke?
Sorry about that. Perhaps you could give us an example of a specific case where you've dealt with a community redevelopment issue.
Well, recently we were involved in one where we got in after the audit letters had come out. And this was not in Central Florida. This was on the West Coast. And working with, and I believe there had been arrests were also made prior to us being called. So that was kind of an all hands on deck situation to try to satisfy the auditor, to try to get the CRA back where it should be as quickly and as efficiently as possible. So we've dealt with CRAs that run very smoothly, where, for example, on the East Coast, there's a different CRA where we call and ask them if they need an attorney present for their meetings because they run very smoothly. Their meetings normally sometimes last between 5 and 10 minutes, and it's not worth the drive to come, and they don't need us. And the others, sometimes there's a fire to put out, and that's when we get called. So both ends of the spectrum.
I asked Patrick to answer first because we've had a few hot and button issues in litigation and some revolving around audits that in the last few weeks that I haven't been involved in. But for one of the specifics I think that I'd mentioned, some of our CRAs are very successful, which is not what they were really intended to. I suppose they have a tendency to be in areas that some of them have over time become rather affluent. And that can create sort of some issues there since it's just meant for redevelopment. Well, some of the CRAs that, or some of the issues I've worked on are really kind of sorting things out between a county and a city where there were some disputes as to, looking at the continuing purpose of the CRA, which really led to going back to the very inception, the very beginning of the CRA, and looking at how it was created and really getting it all organized and from the ground up, putting it back in working order. Because some of these CRAs, when we come in, they have been, they've been in existence for 20 years. They may not have been created the correct way that they should have been created. There may be massive amounts of disorganization between, from those documents where it was created to ultimately where it ended up through various amendments. So in some of these projects, it's just going back from the very, very beginning and completely getting it up and running again the way that it's supposed to be and resolving some of those conflicts. And those are some of the projects that, that's a lot of the CRA work that I have done. Some of our other attorneys have been more involved in litigation aspects, but my expertise is sort of just in getting them going and making them run the best way that they can run.
And to be clear, we don't get hired and come in and say, hey, you need to do all these things. They've contacted us and say, hey, I think we've got problems here. Can you confirm whether we do or do not have problems? And how do you recommend we address them? And then we give them a series of options, and they tell us what they want, and then that's what we do. So, for example, your CRAs may run like clockwork and everything may be perfect. We're not going to come in here and tell you your CRAs run terribly and here's what you need to do. That's not our approach.
Question, I know you kind of mentioned that you represented Apopka on airport issues, but how many cities or counties do you represent currently on a full-time basis? In the last 3 years, have you lost a client or lost a city specifically, and the reason why?
The total number off the top of my head, I think we currently represent.
I believe it's 6 as general counsel.
As general counsel, if we're talking about general counsel, as far as special counsel, it's much, much higher than that. In the past few years, clients have we lost? I represented Davenport for some time after a transition where they had had some issues with their previous counsel, and ultimately they, I believe, 2 years ago, hired a firm more local to that area down in Polk County.
And the city of Apopka has an interesting history, and they had a very long-term mayor. I think, I don't think I'm exaggerating. I think he was mayor for about 60 years. And when he passed, I think he lost an election before he passed. They had a new mayor, first mayor in a long time, and we were hired to come in and represent them. We had a very good relationship with the city of Apopka. They were a large city, they were a growing city, and ultimately they came to the determination that they needed to move the city attorney position in-house with their own in-house staff. That's not what we do, but we assisted them with that, and we still do their development work. So the relationship with them is still strong.
They just became very, very big. It's certainly more suited them to have in-house counsel given their size. But we still provide representation to them on those specialized matters and special counsel in a number of areas.
Thank you.
Can you give me a specific example of like a challenging land use case where you represented a municipality, and then also one where you or the firm represented on the other side, private developer or citizen?
Sure, absolutely. I think I'll let you speak to that one with Ponce Inlet, since you did most of the work towards the end. Pacetta was a huge case that we were involved with over a period of probably 11 years.
Close to 11 years. It was a multifaceted case, but basically it had to do with 10 different parcels of property that were owned by the same developer, or by the same owner. And they wanted to put 35 feet tall three-story outdoor boat storage on the property. They wanted to redevelop to a lot of different things that weren't permitted under the current comp plan when the developer bought property. So as the litigation went on forever, there were 16 different actions that were brought by the developer against the city, from DOA proceedings to county proceedings to trial court proceedings in the circuit court, federal takings claims. It was a massive lawsuit. It ended up, at the end of the day, at one point in the case, the town of Ponce Inlet, which I believe is either 4 or 6 square miles, it's a tiny town. It had, and there's a good ending to this story, but it had at one time a $30 million judgment against it, which meant they needed to talk to bankruptcy lawyers. But that judgment, unfortunately, when you walk into court, you never know what you're going to get in terms of a judge. The judge issued, I believe it was a 52-page decision that was legally, from my perspective, one of the worst decisions I've ever read, legally and factually. But still, that put us in a bad spot. But we were able to successfully overturn that judgment, win 3 circuit court proceedings against the developer, and ultimately, at the end of the day, after all these proceedings, the town walked away completely victorious. We didn't even have to get the judgment in the federal case because we ended up entering into a settlement agreement. Obviously, it was a city, so it's not confidential. You can go look it up. The developer walked away with nothing. But the threat to any government from that type of, I call it a scorched earth litigation practice against the city, you can't control what they're going to sue you for. All you can do is defend against it as vigorously as possible, and they did. They made the political decision to fight. And at the end of the day, they won. The landowner's still there. It's still in development. I think, sore feelings on the side, but that was an intense case. And the town, at the end of the day, the catch was the town was always right, because the development they wanted was always illegal under the comp plan. And the catch, factually, is they never even made an application for development. So their claims were always not even right. But imagine 11, that's really easy to explain. Imagine 11 years of fighting through the trial court and the appellate courts for that very simple decision. The claim was never even right. But it happened and we won. These are interesting fact patterns, both the City of New Smyrna Beach case, I believe it's the plaintiff's name in that case is Kanan, K-A-N-A-N versus City of New Smyrna Beach. It had to do with and it's still ongoing in the appellate court. We don't have a decision from the 5th DCA yet, but we did win at the trial court level. The city has some leased property, or they own some property that they leased to a private club. And the plaintiff sued the city and the private club, alleging multiple constitutional violations and sunshine violations against the city, a host of creative claims against the city. But ultimately, at the end of the day, why I believe we prevailed in trial court, and why I believe we'll also prevail at the appellate court, although it's not final, is the plaintiff never applied to become a member of the club. Details matter, especially factual details. The other case, which is more challenging from a fact perspective, it's also currently on appeal. The briefing is not closed. In the city of Satellite Beach, there was a public workshop scheduled. The city canceled the public workshop, and instead, it had to do with water quality issues. And instead of having the public workshop, staff, members of the press, and some private parties met. And one council member attended the meeting. And then after about 30 minutes, that council member would get up and leave, and another council member would come in and sit. There's no allegations that the council members ever spoke to each other, that they'd simply listened. Think about all the times you guys go to a meeting or a planning commission meeting and simply, two of you there, and you listen. The argument is that that's a sunshine violation. Those aren't particularly difficult legal questions from our perspective, but they're very interesting fact patterns, and you can imagine what would happen to the sunshine law if that was found to be a sunshine violation. So those are the most recent litigations that we're currently involved in, and the previous Ponce case was well reported in the media throughout that 11-year period. Sorry, I know that's a long answer to a short question.
I think we're really proud of the Pacetta case. It's unfortunate, of course, that that there were some bad feelings with that particular member of the community towards their government, but it made good law and made right law. And in the end, that's what our goal was. And I think the point there in talking about some of the litigation is that no one's going to outwork us. Patrick likes to talk about these specifics and the details matter because we go over them with a fine-tooth comb. Remember the details for years to come because we live them. As far as to the other part of your question, looking at things from the other side, for land use decisions, most of our representation, we're hired a lot because we know how things work. When we deal with land use, of course, each government has their own code. We become very familiar with it. There are similarities from government to government. So some of our other work has been assisting applicants in other areas. I've represented numerous applicants in the city of Orlando and Orange County, and some of them have gotten very complicated because of the regulatory structure down there. So I know you'd asked for a specific, for instance, one, it was a veteran-owned company that was in a redevelopment area and had made a purchase and then realized that they couldn't do really what they wanted to do, and just working out with the city and coming to a good solution without litigation is something that I was really proud of in particular.
We do have one case, and I really don't want to go into details because it is ongoing and hasn't been decided even at the trial court level. But you may have heard about it from another one of your interviewees. But it has to do with, we represent a commercial landowner who is in a residential zoned area of a city, but they've been a commercial operation. They're an agricultural, outdoor storage, landscaping business, and they've been there for around 60 or 70 years doing the same thing. They started getting code violation notices for what they had on their property, their shipping containers that they had on the property that had been on there before the code was written. And they went to a hearing, the violations were upheld. They hired us to appeal the decision based on the property being a legal non-conforming use. We'll see what happens with that. But those are, we certainly don't make a business out of representing people against governments, but sometimes if there's no conflict and it's a good case, or we think it has merit, sure, we represent our clients. And from my perspective, our work with local governments is aided by the work that I do for private clients. It allows me to do it at a below market rate, and it also helps frame my perspective about the legal issues you face, and to hear from the developers and with the attorney-client privilege of what the issues they're seeing. And it helps us when we want to resolve issues short of litigation before they become a problem. It just kind of adds to our education and our knowledge.
Just to expand on that a little bit, do you currently represent anyone that you could foresee being a conflict of interest as if you were the attorney for the city of Leesburg?
No, sir. No, I don't currently. I don't think any of us currently represent any commercial. Let me take that back. I do represent one commercial party that has property in Lake County, but it is not in the city of Leesburg.
City Manager, you have any questions?
Something earlier about APOCA going in-house on their attorney. Do you see a definitive line when cities go from law firms contracted to having an in-house attorney?
I think that really depends on the budgetary goals of the city, and I don't see a definitive line, but it's apparent when I think the time is right for them. Simply being that when a city has grown to the standpoint that they can support, an entire legal staff, and that they want to have full-time working solely for that city, that's when it's time. Popka is huge, and while we served as counsel for them, didn't grow too much annexation-wise, but development took off. So they were ready. It just became clear. As far as indicators, I think that's really about it. When they really can support that staff that is working for them just full time is when I think that they're ready. Do you have anything to add to that?
I do. Just we had a very open relationship with the Popka, and so we talked about the pros and cons of them going in-house. And one of the concerns I had for them was, okay, are you going to have a city attorney, assistants, and a full staff so they can actually focus full time on it? You're going to devote the resources to it. Well, think about the proposals you've seen for the flat all-in rate. How are you going to pay somebody, a city attorney, that salary, have staff to support them for that same rate? At some point you can. At some point, if you're willing to expand your budget, you can, and it makes sense to have your team of dedicated attorneys that are there. But until you kind of close that gap and you're willing to commit those resources, from my perspective, going in-house with one attorney by himself without staff for the same price you were paying for a firm, a team, an army, if you will, of attorneys with staff, I think that poses challenges. So that, from a budgetary standpoint, that's how I would look at it. When you get to that size, you need to budget for having 2 to 3 attorneys plus a dedicated staff member before you really want to make that change.
I think that's a good answer, and I think what I would add onto that too, when a local government goes in-house, they should be hiring special counsel really at a minimum. We still do special counsel for a number of in-house cities, but their legal staff should be capable of handling the broad spectrum outside of something that's very specialized. And so that's another sort of criteria I think that's important. When a city can support a team, and when the city is then capable of pretty much handling almost everything that could be thrown out, when they're ready to go full counsel.
Well, I'll wrap this up with a closing question, and just tell the commission why we should select your firm over the 3 other firms we're interviewing.
Well, I think, first and foremost, we know our role. That's something that we've talked about. We're here to empower and make good decisions. We know that. Not everybody knows that. Some other firms do. In addition to that, we bring a wide realm of expertise. I said local government is our cornerstone in practice, and special counsel is probably the biggest part of that. So when city attorneys are having problems and they need to call an expert, they call us. Of course, serving as your city attorney, you don't have to call those other experts because you already have us. And I think that's our strongest suit in every practice area in local government.
You have a difficult task before you for a couple of reasons. I mean, you had Mr. Morrison for 30 years, and the rate. I think I looked at the rates that he charged over that time period. They didn't go up very much. They didn't, and you're in a situation now where we're in a huge inflationary environment, but you have proposals that come in. Paris, I think are.
I'll just add to that.
Yeah.
We had Fred for 30 years on a letter of engagement.
Yeah. And that's special. Those opportunities are few and far between. And I also know, look, I was here for your earlier meeting, and I know some of the other firms had a relationship with his firm. They used to work there. You know them. They're a known commodity. And I also had the benefit of hearing how we got to come to this interview. So, look, we realize the realities of it. But in terms of why you should select us over the other firms, I think this has to do with my litigation background, and it's not very, I guess, humble. But whenever I'm sitting second chair at a trial and my colleague is making the argument, I always in my heart think, man, it should have been me. I could have done better. And I will just simply tell you that I have confidence in my colleagues at our firm. I share some of your concerns that you raised about the flat rates that are charged and the difference in the breakdown. That's very challenging to do. And one of the things that we confront whenever these opportunities arise, these RFPs, is there's usually one firm that comes with a low ball number. And trying to make that low ball number actually work in the real world, when for 30 years you had $135 an hour, $150 an hour, those are not market rates today. So how do you make it work? The only way from a competitive standpoint that we've been able to determine to make it work is through the pass-through fee ordinance that allows us to do market rates for your development work.
All consultants.
On consultants. All consultants, right. And, so, and in addition to that, being able to do other litigation. Frankly, I don't know how a firm could survive on some of these rates that they charge if it's all inclusive for litigation. Could you imagine if we gave you that flat rate and you had a litigation that lasted 11 years like the Ponce Inlet case did? The reality is at some point that relationship is going to have to change, because we can't do 11 years of litigation for $108,000 a year, let's be frank. So anyhow, what you would get from us if you hired us are frank, honest discussions at all times.
Thank you both very much for your time. We appreciate your interest in the city attorney position.
Thank you very much.
Thank you
It's a
all.
pleasure.
Thank you for the opportunity to be with you. Good luck.
Can I ask one question before you leave? How common is a pass-through situation that you're suggesting? Is that common practice for local government?
Yes, very common, very common. It's, and just to, I think Patrick touched a little bit on it, but just to give you kind of a little bit more, just the real long and short of it, it's just an ordinance that when, for instance, if you had a developer come in, they pay their application fees, and in addition, they just pay a deposit. And then that deposit, if the city engineer needs to take a look at something, if a surveyor needs to take a look at something legal, then those fees are deducted from that deposit, and then the deposit is renewed until the application is heard by the council. So it essentially allows or requires the developer to pay their own way, so that the taxpayers are not the ones that are funding the development. So it is very common because it protects the taxpayer, it protects the city, and it places the individual who's ultimately going to receive the benefits of a particular decision in place that they incur the benefits, they incur the costs. So it's the fair way to go. So it is very common.
Yeah, thank you again.
Thank you all. Have a good day.
Yes. What's the matter?
We switched these aren't,
What about?
they don't match up.
Well, yeah, the numbers don't match up anymore, but who cares?
Took
We
me a
know
little
it.
while to
Yeah.
figure that out.
Okay, that's that.
We get the next strip painter out, frame them better.
Oh, it don't matter.
He was
It's
sitting back
moving
in his
today.
chair before.
Oh, that. Yeah, got it. Gotcha.
it's been so long, so I know. You gotta follow the pharmacy, you gotta wait to put over there, but you be back next week, but you have to go return flight. Flight comes this Sunday, you come back next Sunday. No way.
Quickly.
Five. Yeah. I don't know what to tell you. Nobody's put up one more mic. Gary.
Yeah.
give us just a couple of minutes. We have one commissioner outside. As soon as he steps back in, we'll start.
Yeah, I need about 2 hours to program some stuff, and we're ready. It's all there and ready to go.
But we'll go ahead and get started. On behalf of the City Commission, welcome. Thank you for your interest in the position. I'm going to start with Mike Thornton. He's going to make some opening comments. Then I will open with the first question. The Commission will take turns with questions, and then I'll wrap up with a closing question.
Thank you, Mayor. My name is Mike Thornton, Purchasing Manager. Today is February 23rd, 2022. This is the interview meeting between the City of Leesburg and Stone and Gherkin, PA for request for proposal 220042 for City Attorney Services. An interview session has been scheduled with the 4 top-ranked firms. This is the final interview. This interview provides an opportunity for the firm to address questions asked by the city. The interview is scheduled for 45 minutes. The time will start when the first question is asked. The interview questions have not been provided to any of the 4 firms. With that, I'll turn it back over to the mayor.
Okay, thank you, Mike. I'll start with just ask you to take a few minutes and provide the commission with your background qualifications for the city attorney position.
And my name is Grant Watson, and I'll kind of introduce everybody here at the table for everybody. Again, my name is Grant Watson. We got Louis Stone here to my left, Scott Gherkin right beside me, Kevin Stone, and Francesca Sabatini. We are all of our attorneys at Stone and Gherkin have come here to meet with everybody today. We're very excited about this opportunity. We think that you guys have a great city here. It's a beautiful location we're at. Some interesting city services like your international airport, your utility services, and we believe that those types of things really mesh with a lot of what we do. I grew up in North Florida, small town, Fernandina Beach, Florida, just north of Jacksonville. Went to college at UCF, went to University of Florida for law school. I've spent my entire legal career here in Lake County. I got my first job out of law school working at William Smith & Summers in Tavares with, some of y'all might know, Gary Summers and Bob Williams. I also worked with C.J. Smith there. But I worked there out of law school, as I said, basically doing a lot of general civil litigation, contract work, doing some local government work and real property. We did work with the tax collector's office and the city of Tavares over there. Really enjoyed my time and had great respect for all those guys, but after about 7 years, I decided to set out on my own, start my own firm in Mount Dora, where I continued a similar practice of general civil litigation, doing a lot of real property and contracts, continued doing work for the tax collector's office at that point as well. After about 2.5 years or so of running my own firm, which was certainly a different experience than my first job working at Rowan, Smith & Summers, had the pleasure of an invitation to join up with these fine folks here at Stone and Gherkin, and just really a great group of people, and I'm just very happy and thrilled to be there. The firm, and certainly I can let everybody sort of introduce themselves a little bit, but the firm was founded in 1992 by Lewis and Scott. It has always been located in Lake County, has always had a focus on providing representation to local governments and utilities, and that focus has continued today. All of us at the firm, all the attorneys do work with our local government. Some of our clients that we're blessed to work with are the cities of Mineola, cities of Umatilla. We represent several dependent and independent special districts within the villages. SECO is another one of our clients. So we believe that the issues and things that these clients deal with are very aligned with what the city of Leesburg likely deals with. And so we think that provides us a pretty good, solid foundation of experience and background and being able to help the city and work with the city. So, with that, we've continued that focus. We love and have great respect for the cities in our county here, and we just really enjoy that type of work. And so, again, all of us do it. All of us work with our local government clients, and we think that your city attorney position really fits in well with what we like to do.
Thank you very much. So I'll start with Commissioner Burry. We'll just go around the table.
Yeah, hi, I'm Jimmy Burry, represent District 1. What are some of the issues facing our city that you're familiar with and that you may have been following, and how is your firm situated to deal with those?
Well, I think some of the things that we know about, from the outside looking in, again, you have your international airport, which is a unique service sort of to the county here. We do have some experience with the city of Umatilla, who has an airport. It's not international, but we deal with some airport issues over there. So we think that would be consistent with that type of work as well. We know, again, that the city here provides a wide range of services with your electric utility, gas, and things of that nature. Again, our cities that we represent don't provide those services necessarily, but we have clearly some experience in working in the electric utility business, as Lewis was with SECO for 20, 30 years, something like that, and Scott's taken over that role at this point. So some of those issues, and then of course just your local government issues with contracts and expansion, and we know there's development and things going on. So dealing with planning and zoning and those types of land use issues and all that, I think our experience and knowledge dealing with those issues is something that would be valuable in the city as well. We do it on a daily, weekly, monthly basis, and we just think that again, all of these things are consistent with what the city does. Certainly, we would be looking to meet with all of you as quickly as possible to really get a good feel for what the real big issues are at this point in time, so that we can sort of pick up where those are and help you guys navigate those and plan moving ahead in the future as well. I don't know if anybody has any other comments or...
Yeah, just to add to that a little bit, like most of the cities in Lake County, we realize there's a lot of growth issues that are going on with Leesburg as well. And, we're all trying to balance the growth with serving the historic main city and trying to keep all the constituents happy at the same time. we've been the city attorney, for instance, for Mineola for over 20 years. And Mineola, when we started there, was a town of about 1,400 people. And now I think it's over 15,000. And if anybody's been down there lately, you'll see the massive growth that's going on there. One of the things, as city attorneys, we realize we need to help you all with that growth, but you all make those decisions. And we understand that very much, that sometimes it's tempting when you sit through all the meetings and everything to sort of want to put your 2 cents in, but we realize that that is the elected officials' job to do that. And we really appreciate it and focus on that. It's funny, I actually filled in at Leesburg meetings, I think back when Ski Beach was first talking about being developed at one point a number of years ago for Fred. And I see that a lot of those projects are moving forward. It takes a little time sometimes, but that was, I don't know how many years, I think there were terrazzo floors in here at the time with the old building, wasn't it? Yeah, exactly. You were meeting at that time. This is the pool, exactly. And on a personal note, we're obviously a Lake County firm. I mean, as Grant said, we're here, and some can look at that as a good or a bad thing. We are very careful about conflicts. I mean, we do represent other folks within the area, but it was a pointed issue that we came for Leesburg. If you look at the cities and the people that we represent, we don't envision any conflicts with Leesburg here. Mineola is a South Lake County. Umatilla is just east of the Golden Triangle, and Leesburg is in this area up here. So that's something when we applied, we were sensitive to that. The other thing is we do want to say we appreciate you considering us. Frankly, Fred, we all knew Fred very well, and he gave me my first job as a lawyer when I came out, when I was in law school. And not that it has anything to do with the selection, but we just we appreciate you considering us, and we acknowledge your loss, and frankly the loss to Leesburg of losing Fred. We thought a great deal of him. He was sort of the dean of local government attorneys in Lake County, and so we appreciate the chance to, almost hate to say step in, but to assist if we can.
Good morning. What role do you see your firm taking in our organization? Example of primary or dedicated attorney, or will you have a team of attorneys who will service Leesburg?
I think our vision is that I would be the primary attorney, that Scott would sort of be the secondary, but as we were saying, we're all fully capable and happy to work with the city. So, if I wasn't available for whatever reason, any of our attorneys are more than happy and willing to work with the city and help out. We've all covered plenty of city meetings, even planning and zoning, city commission, city council, various boards and things that we provide representation for, and we all talk and deal with those clients. And so, although it would be primarily me, and I would be devoting a great deal of my time to the city of Leesburg and all of your issues, it would be somewhat of a team approach in the sense that we all work with each other, we all support each other, and some of us have more specific knowledge in certain areas. Again, Lewis's knowledge and experience with electric utilities is perhaps unrivaled by anybody in the area here. And so he's a great resource for those types of issues. So I think we all work together in a sense, and we would all be here and be happy and willing to help the city with whatever was going on. But our initial approach, or at least our perspective, is that we would dedicate me to the city. Scott would back me up as needed, and we'd all be there, to help as necessary.
Thank you.
Yes, sir.
So you alluded to representing CityComm for, it sounds like, quite a long time. Could you talk a little bit, give maybe some specifics on the type of work you do there?
Yeah, I don't do as much with CityComm. I do some things with some of their easements and that type of thing. Scott is really CityComm's counsel at this point, so I think he could probably provide some insight. And Lewis, again, certainly has worked with CityComm for decades and can also provide some more insight on that.
I represented Sumter Electric as general counsel for, hard to believe, 34 years. That's why I'm the old guy. In the last few years, as I'm winding my way towards retirement, I stepped back and they took Scott Gherkin on. There are a plethora of issues that electric utility is involved in. As at the beginning of the representation, I pretty much was a soup to nuts guy. Over the years, as they grew and issues became more complicated, they tended to hire outside experts for example, labor negotiations. I mean, they're unionized, and as a result of that, they have labor contracts that CityComm would hire outside counsel for. We'd keep our nose in it, but we wouldn't be lead counsel for specialty items. Certainly stuff historically with the Public Service Commission involved in making sure the I's are dotted and the T's are crossed for rate setting and those sorts of things we were involved in. Territorial agreements, franchise agreements, we were certainly involved in those. The good news is, I mean, when we speak of the potentiality of conflicts, I mean, I think we have, CityComm has recently signed a fairly long-term territorial agreement with the city of Leesburg, which actually went very smoothly. About 25 or 30 years ago, it did not go smoothly, but happily those days are behind us, and this time I think that went very smoothly. So I think the budding territories issues should not come up for quite a while. And frankly, the franchise agreements are pretty standard. Basically, everybody gets a favored nation clause, and the way those work, everybody has the same franchise fee. So I don't really see an issue with conflict as that as well. But easements, I mean, back in the day I did condemnation work, taking cases to trial, all the way from acquisition through trial. It's you know, with any organization, and certainly cities are like this as well, if you say what you do, it kind of depends on what the day is and what the issue that came up at that time. But we did a general scope of work for them for a long time, and happily for me, Mr. Gherkin is doing that now.
Yeah, representing CityComm or an electric cooperative is not unlike a city in many respects. As far as we are general counsel to CityComm, they have their own in-house attorney and a whole crews of others, as Lewis said, depending on what the specialty is. As your city manager going to test electric industry as its own special thing, and there's a lot of specifics that go into that. As general counsel, we sit with, they have a board of trustees that's elected, it's electric co-op. I sit at the board meetings and do generally what you'd see as a city attorney does here, but oversee and generally responsible for all the legal functions of the co-op. CityComm is now a $1 billion in assets entity, and they have a lot of customers, but as Lewis said, we thankfully, and that's one of the things we checked, the franchise agreement is in place and is fairly standardized in any event.
Al, please.
But it just popped in, and I think it's timely to ask you. One of the things that I think is interesting about Leesburg that could be a challenge, and I'm interested in your opinion, is our growth. But so we've got 27,000 electric customers and growing, but all of our growth is in the south, which is going to be Duke and or CityComm territory. So in the next 5 to 10 years, we could have 20,000 new residents who are going to be not in our electric system, but in our city. Do you think that that poses challenges to us, and how would you advise the commission on that? Or what potential issues do you see rising from that type of pattern?
Well, clearly, if an issue does rise to the level of a conflict, it's not like our representation isn't known to like everybody, so we would make sure to avoid that conflict, follow bar rules with regard to that, make sure the city was well set, make sure CECO was well set. Generally speaking, the territorial agreements tend to control, although as we know in the electric industry, there are times when, because of growth patterns and because of existing facilities in the field, swaps and changes are made just because it makes engineering and or safety and or financial good sense to do that. I have not checked, and I don't know what your rate of return is for your electric utility, but certainly the 6% franchise fee in the event of not doing the electric yourself is, generally speaking, for most utilities in the general nature of profitability for the system without having to endure the obligation of providing the service. I mean, but if there's conflict, obviously we announce it and we make sure that the sides are well looked after. Generally speaking, territorial agreements are intended at the time they're created to be what's done, but there are engineering and safety and economic reasons to make changes from time to time. I'm sure you've seen that.
Yeah, and as you know, obviously the Public Service Commission obviously will eventually weigh in if there is a territorial dispute, but we actually think that our involvement with local governments and with electric utilities helps in those instances, because you can understand the incentives of both, and frankly also knowing the area quite well, we can help sometimes avoiding conflicts, but help sort of remedy any issues that may pop up.
Good morning. Just to expand on that a little bit, other than the cities you've mentioned and CECO, is there any other clients that you represent that you could see potentially be in a conflict if you were the attorney for the city of Leesburg?
Well, of course, and once again, as the old guy, I've backed off from this in the last couple of years, but we have represented the commercial community development districts at the villages. Springwood Landing, Village Center District, Brownwood, and we have also represented the utilities, North Lake Sumter, and now the new utility springing up. I know they call it Wood. I mean, everything over there, has initials, but it's the Wildwood Utility Dependent District. The utilities are dependent districts. Of course, they're tied to local governments. They're dependent districts of the local governments. Is there a potential for conflict there? There is. Do I see, sitting here, do I see a big potential? I don't, but I should disclose that, that is a client we represent, and there is the potential for conflict. Once again, we're well known that we represent these people, and so we would certainly follow bar rules if that came up. I think what we're just trying to say is that our firm has done local government utility work for forever. I mean, that's just what we do. I was city attorney for Eustis for 18 years. We've done Umatilla. We've stepped in and represented local governments in other contexts. I've been special master, and still from time to time serve as special master for the land use issues. How you can go to special master on those for Orange County, for Claremont, other cities for Lake County. So I just would say that we feel like our heart's in the right place, that we are people who enjoy local governments, that understand it, that it's not our place to be elected officials, that it's our place to assist elected officials. You guys are the people who are elected and need to be the ones making the decision. But I think our track record is that we're very good at assisting you in doing that and spotting issues that are important.
Yeah, and specifically, we don't represent any of the developers that you're going to be seeing in this area, the home builders and those folks. We specifically have not represented those to avoid any kind of conflicts, which is where most of those conflicts that you're seeing would occur. There are a lot of local government attorneys that play both sides, if you will, that represent both developers. But outside of a few, almost what I'd call mom and pops that we do work for, none of whom are doing work in the Leesburg area, we don't have any conflicts in that area.
Yeah, and just, sort of jumping in to add on to that, I lost my train of thought. Let's see, yeah, the land use stuff, we've actually sort of made a firm-wide decision to not really take that on in the private context because of the fact that we knowingly represent local government bodies that are reviewing these applications. So while we do a lot of land use in the context of reviewing, helping development staff in the various cities and that kind of thing, we don't really do it for private clients in that same sense. And again, a lot of the reason we don't is to try and limit the areas where we would have conflicts. And certainly that's an area, as Scott said, if you've been to Mineola over by the turnpike, it's all dirt now, just building houses everywhere. And so, we're sensitive to that, and we try our best to avoid that. As Lewis said, if an instance does come up here and there, we think it's our job to make sure you have competent, good counsel to give you advice, to give our clients advice if we're not able to help. And so in those rare situations that it might come up, we do want to help make sure you guys get to good counsel that's going to help you and take care of you, and try our best to just not get involved in the lines of businesses that really create or conducive to those types of conflicts.
And let me speak up one more time to just say that you guys won't need to worry about who you're supposed to call. I mean, Grant will be the contact person to call. But there's always going to be somebody. And the work can be shared around the office. If Grant is not available, it'll be Scott. But if for some weird reason Scott and Grant aren't available, the rest of us are there. But you wouldn't have to guess about who you're supposed to call. You'd call Grant. The other thing is that we do pretty well operate as a team from the standpoint that we regularly meet and run problems and issues by one another, so that we have input from several heads on almost anything that amounts to a significant decision or legal position to be taken. So the reason we're all sitting here today is because we operate as a firm, and we wanted to make that clear to you.
Thank you.
No, thank you. You've actually answered all my questions through your answers so far, so I'm just going to open the floor up and just instead of just going around, just keep it informal. Any commissioners have more questions? I'm sure I will eventually.
Yes, so part of our mission statement, the number one goal of Leesburg is we want to eliminate blight, stimulate growth by investing in neighborhood redevelopment. Can you give us some examples of how your firm has been involved with either community development districts or cities in general in achieving those goals?
One of the good examples that we could do.
Yes, we've actually represented several CRAs for the cities we've represented before and are very familiar with all of the issues that come along with that as far as the tax increment financing and the things. That's again one of those issues, like I talked earlier, of trying to balance the needs of the traditional historic town and city, which you obviously have here in Leesburg, with the needs of the growth. And that certainly is one area that you can, with the redevelopment, that you can do that.
We have a lot of experience with community development districts. Most of that experience is in the villages, which is a little bit different from the kinds of blight and redevelopment activities that you're talking about. But it does give us a familiarity with those structures and the resources that are available to those kinds of entities. But the reason I spoke up here is that in Umatilla, we have a community redevelopment agency that I'm really proud of. Umatilla is not a place that a lot of people think about very often, but I do. And they have done a lot of interesting things with tax increment financing to try and redevelop their downtown core. I think that you'll be excited to travel there at some point over the next few years if you do need to leave Leesburg for any reason. They have, established new zoning districts and overlay districts and are giving out facade grants left and right to businesses and, using the zoning code and their land development regulations as best they can. I don't want to get in the weeds with that, but I can tell you that those kinds of projects are very interesting to me, and a lot of my focus is on the ways that we can use the financial tools available uniquely to municipalities to participate in those kind of redevelopment programs.
Have you mentioned something, you said real briefly, you're caught on your facade grants and you're doing that in utility. We're doing that here in 3 different ways with our facade sign landscape grant that we've had a couple of years. We just implemented, we haven't done an award on it either, the redevelopment downtown grant. Have you had issues with using those funds, or have you seen problems that arise out of using money in those fashions for redevelopment?
Nothing serious that was difficult to overcome. So one of the frustrations that Umatilla ran into, and especially with all the money that's been flowing from especially the federal government with COVID, is that it's hard to find good ways to spend the money that's available. And sometimes we have more money than we're able to spend. And what we found in Umatilla was that a lot of that was a public education issue. That when we got people knocking on doors, letting them know what the opportunities were to take their little bit out of the blight, to do their part to increase their taxable values by using that grant money, it's a win-win. And so for us, if we had issues, it was just in communicating the existence of the programs, what was available, and we overcame those. As far as the implementation, receiving the applications, getting the awards done, having them done efficiently, ethically, and resulting in the kinds of improvements we were expecting, we've had a lot of success, and I really can't say that we've had issues to overcome. I wish I had a better story of beating a challenge, but...
No, that's a good answer.
I haven't been city attorney for Eustis for quite a while now, but they also had that. And just trying to think back through problems. One of the problems, just kind of a nuts and bolts problem that we had at the time, wasn't in securing the money. It was in making sure that the contractors who came in and were going to be the persons who were going to be performing the work understood the scope of the work, and there were some issues. This is a long time back, but just as an example, there were issues about quality of work and contractors that would come in because there were time limitations, and there were some issues around that.
Could you give me a specific example of a challenging land use case where you've been representing the governmental entity, and then, if applicable, also if you have one where you represented a private entity against a government?
Sorry. Back to what we were saying, we've sort of made it a focus to not take on these private land use disputes. So I can't really point to any specific example of a private client or private company that has really butted heads with a local government, and we were involved with that on the private client side. You know, sort of as we've been talking about with the city of Mineola, and I do a lot of work with that city and their land use planning and zoning, and there's a lot of development going on over there. A lot of PUDs, a lot of developer agreements, a lot of issues to sort out with the amount of development going on. You know, mixed use development in terms of residential, commercial, industrial, lots of different components and unique design criteria that you know, shifts throughout time as well. So you know, I don't really have, at least personally, a good example of where we've had significant disputes with those landowners. We meet with them a lot with city staff, and obviously at city meetings, planning and zoning meetings and all of that. And we talk to these folks, you know, outside of city meetings as well, trying to work out whatever issues exist. But I think, you know, for the most part, my experience in those issues has been very good. You know, everybody, there are some little challenges that come up here and there with, you know, commercial components and industrial components and residential, and trying to blend and mix those, and school sites and park sites and things like that. But I think we've had a lot of success in working with our clients and the property owners within their boundaries that are looking to develop, and sort through whatever issues or problems come up, and those projects are running forward, and you know, we're proud of what's going on. I don't know if anybody's had any disputes.
Yeah, I was
really. I know you guys might have.
We talked about this earlier. I'm not aware of any dispute representing a property owner that we've had, because we avoid that. There's nothing wrong with attorneys representing both developers and local governments. We understand that as lawyers. We also understand a lot of people that are serving don't understand that. And frankly, I don't want to lay in bed at night arguing that 5 units per acre is perfectly reasonable for the developer, and then be sitting at the dais when somebody comes through and feeling guilty that the city may be denying it. I see where people can perceive a conflict, and we just choose to stay out of that. As far as challenging land use, I mean, it's just to harken the same example with Mineola. They have, for those of you familiar with the area, they have the Sugarloaf development, which is the development that was approved by the county in the 90s as a large, nearly 2,000 acre planned development. They also have the Hills of Mineola, which was a DRI that was formed, which is over 2,000 acres. So you have, between those two developments, over 4,000 acres of planned development that's within the city. We've been involved throughout the last couple of decades with those processes, both the DRIs coming from the county to the city, dissolving the DRIs through the process, frankly, because we had CRAs, and then going through and dealing now with all the plethora of the builders and developers that come along now. One thing that I'm sure you all appreciate is, believe it or not, the code isn't always specifically absolutely clear on every issue that comes through. And one of the things we try to assist our local governments with is just being reasonable and making sound decisions that are good, frankly, for the local government, but that are fair for the folks that are coming before them. And it's hard to hit that balance sometimes, but that's what we're shooting.
Yeah. And just one final thing I'd add on that too is I sort of had the unique experience of acting as the City of Wildwood's special magistrate for local planning and zoning, and code enforcement as well. So they're not representing the private companies in that context. I did have the interesting perspective, I guess, of rendering decisions on those issues for Wildwood for several years as well, which I thought was very interesting, and was really a good experience. Yes, sir.
Any other questions? Okay, go ahead, Mike.
One thing we discussed at the commission meeting was, in your fee proposal, you included an attorney and a paralegal hourly rate. Do you know what the percent breakdown might be between those services?
Between the attorneys and paralegals?
Yes.
I think, to an extent, it would be something we would sort of get a better grasp of, I think, after we see, meet with everybody at the city, see what's going on. A lot of I would anticipate a lot of time would be spent by the attorneys. When we're looking at legal issues for the city, of course, we're going to have our hands in that. In terms of drafting ordinances, things like that, talking to staff, reaching somebody at our office, certainly we'd have paralegals involved with that. And to the extent, we can have them drafting things, whether that's easements or contracts or anything like that based on forms that we've already developed. We will ask for their help wherever we can. We understand fiscal responsibility is something that all of you certainly are paying careful attention to, and we understand that. And so where it makes sense for us to use paralegals, we will, so that we can give you the benefit of that rate reduction. But there will be many times where the lawyer needs to be involved, and whatever the paralegals prepare and are involved with, we will still be involved to an extent, but not as fully involved, I guess, if they're preparing things. But again, we will do our best to use our paralegals and our staff, because we have the utmost confidence and faith in all of them. All of them have exposure to local government work, and so we would use them where it makes sense.
Yeah, no, thank you for that question and answer. Anything else, commissioners? If there's no other questions, I'll just close with asking you to explain to the commission why we should select your firm over the other firms.
Well, I think, from my perspective, I think that what the city does here, it really fits with our day-to-day, day-in practice. We like this type of work. We like the land use. We like the contracts. We like the utilities. It's all interesting to us. It's all challenging. It's always changing and evolving. And, we pay attention to these things because we have to, because we have a number of clients that have similar interests. And we're here. We're all here today. We all, again, take a team approach here. We support each other, and we support and love our clients. And, we're 100% dedicated to our clients, doing what's best and right by our clients. And, we really work here in the community. We have great pride in this community, and we have great respect for all of our local city leaders. And we think that we fit in very well with that in providing legal representation to those cities and boards. And we're dedicated to what we do. We love it. We're interested in it. And we just think that we would fit well.
We not only represent a bunch of local governments and other significant institutional clients, but we tend to keep them for a really long time. And that's, boards come and go, and I think there's something to be said for being able to establish that institutional knowledge and continuity, and you can't keep that up if you don't have good interaction and provide the service that the client's looking for. And we feel very confident that we can do that. When you live in a small area, there are not that many Leesburgs out there. So when the opportunity comes around that we're considered, we certainly want to be in the mix, and greatly appreciate this chance.
Yeah, we would hope if you would check the references. Feel free to do that. You know the folks that we've worked for, and I'm sure they can speak honestly about the work we've done for them. As Lewis said, I think one of the strengths of our firm is we serve as general counsel to the city and other clients, and frankly get to know the people that we serve and have served them for a number of years. To take the pressure off you, we know the other firms that have interviewed with you, they're all fine firms. You cannot make a bad pick. We do think we bring to you the distinction of a firm that is well well-known and we like to think respected in Lake County, and that we don't, as Lewis says, we don't go after, frankly, this is the first time we've interviewed for a city perhaps in over a decade. We have not done that, but Leesburg was right. It fits in with what we do, given what the city does, and we would be very honored if you were to select us to be your attorneys.
Well, on behalf of the commission, thank you very much for your interest, responding to the RFP. I appreciate the whole team coming out, and I mean that sincerely. Anything else, commissioners? Okay, thank you very much.
Thank you. We appreciate everybody's time.
Thank you.